Hi students, Professor Orenberg here, and welcome to our series on organizational choices. This will be a series of videos covering which type of business association to form and why. And we're going to break this apart into a series of smaller videos to make it a little easier to remember all of the details that are involved in the study of business associations' organizational choices. So let's get started. This series is going to proceed with 6 videos. First, we're going to introduce the process of selecting a business entity by reviewing 7 issues that are going to come up time and time again when deciding what entity to choose. We're then going to discuss the 4 major types of organizational choices: general partnerships, limited partnerships, C corporations, and limited liability companies in the context of those 7 issues, forming a matrix of effectively 4 entity choices by 7 issues. And then in our 6th video, we're going to summarize everything by briefly noting some alternative organizational choices that can be used for professional groups, and then summarizing the 7 issues across this matrix of 4 types of organizational choices. And in that process, you will learn the differences between the 4 major organizational choices and when to select one or the other for basic business planning purposes. This is the first video in our series on making organizational choices, and we're going to begin by briefly discussing the types of entities that we can form or incorporate, introduction to the entity types. I'm going to mention briefly why the state of incorporation matters, and we'll allude to the video on the internal affairs doctrine when that comes up, because the internal affairs doctrine states that the state in which you form or incorporate governs your internal affairs of your business. And then we're going to introduce the 7 issues that drive the decision of which entity to form. There are a lot of different types of business entities in America and elsewhere. We're only going to focus on a select few. In fact, we're going to really focus on a select few of those select few. But the basic scope of business entity choices range from, on the one hand, very informal relationships, a sole proprietorship being the most informal, that's just a person, an individual doing business for themselves, has no liability protection, no official filings, no paperwork is necessary to create it, it sort of just exists. And we then see to the left of that the general partnership, also relatively informal entity choice that can be formed without any proper filing or any type of fees. There are some versions, newer versions of general partnerships that have bells and whistles, additional features. These do require a separate filing: limited partnerships and limited liability partnerships. Skipping over LLCs in the middle for a moment, on the right-hand side we have corporations, and corporations dominate business in America. Certainly most large organizations are structured as corporations. Within that, corporations can make elections to be treated, for example, as an S corporation, which is a tax election, or as a B corporation, which is an election to give the directors authority to make decisions in the public interest and not just in shareholders' interests. So there is some flexibility with how corporations are designed. But moving back to the left, limited liability companies are the ultimate in flexibility. They can be designed to function like a general partnership, like a limited partnership, like a corporation. They can be taxed like an S corporation or like a C corporation. So the best way to understand LLCs is to understand, on the one hand, general partnerships, and on the other hand, corporations, and then recognize that LLCs can have attributes of both. Sometimes we refer to all these nomenclature as an alphabet soup, because there's all these suffixes that one has to remember. And so that is part of learning the laws, to just get a sense of the key terms that we're going to be using. So GP is for general partnership, LP is for limited partnership, LLP is limited liability partnership, LLLP is a limited liability limited partnership, a C Corp is a standard corporation, an S Corp is a corporation that makes an S tax election. A B Corp or a benefit corporation has made a B Corp election. Then there are LLCs, which are limited liability companies. More recently, an L3C, which is a low profit company. And there are a few variations of those as well. getting into member managed versus manager managed LLCs. So it's a lot of nomenclature, but really the key thing to remember is these are abbreviations that refer to a set of default rules. And by first examining what are the issues that businesses face, we can then determine which set of default rules are going to best apply to resolve the issues of that business. So we're going to learn about the entity choices through a practical approach, learn about these not just in the abstract, but to understand how these different suffixes relate to different substantive law that will apply to our company. There are 7 issues we'll focus on in business planning, and we will apply these 7 issues to all of the entity choices that we are going to make. As a lawyer involved in incorporation, we play multiple roles. We function as lawyers, of course, and thinking about legal risk, but also thinking about business risk and about business management. So what are some issues that we want to raise with our client and help them think through as we structure this business plan together? First is formation. When does this company begin? When should it begin? When will people invest in it? What types of formalities need to be observed in order for it to be created? Are we willing to incur a significant amount of time or expense in forming the company? Is it something that's going to have a long duration, in which case those formalities are sort of inconsequential in the scheme of things? It's a very short operation. It may not be worth having all those formalities. And moreover, a formality would include filing with the state. So do we want to make this public? So what types of formalities are we willing to go through and expenses, and what do we need in order to have a certain type of entity be created? The second issue will regard liability for business obligations. Who is liable for the company's actions? Is there going to be some type of non-recourse structure where the shareholders are insulated or protected? How about the managers? Are they going to be liable for any torts or crimes committed by the business, or for any contracts that the business doesn't honor? How about respondeat superior, the doctrine that let the master answer? Which of the management are going to be answerable for any of the harms caused by any of the workers? In other words, when are the shareholders, directors, and managers, and employees for that matter, liable for the business operations? And to what extent is this a high liability business? The higher the liability of the business, the more we're going to want to build in liability protection. Third are control rights. Who manages the investment, who controls the business, and who has the ability to bind the business to do new things? So control rights is a general term, but one might think of having a seat on the board, having a vote in the shareholder meeting, having authority to take actions without further board consent, having an officer title. There are various ways that we can apply control. And in some institutions, it's appropriate for all the investors to have a great deal of control. In other cases, the shareholders generally have no control. So depending on how much control we want the shareholders to have and and who's going to manage the company and how, we might make a different entity selection there as well. Fourth up is financial rights. Obviously very important to those who are going to business for profit, is thinking about how those profits will be shared or distributed. So financial rights regards the return on investment. Where are the profits going to be allocated? Who is going to come up with additional capital contributions if there are losses? How are people going to pay tax? Is the tax going to occur at an entity level, in which case the business pays tax before the shareholders or owners see anything? Or is it going to be taxed on a shareholder level, in which case there could be issues with shareholders incurring a tax bill before they get cash from the business? And how do we want to manage these financial rights? Who makes the decision about whether the company is going to issue a dividend for its profits or to reinvest that money? And so all those financial rights need to get ironed out at the beginning as well. Next up is continuity of existence. How do investors get in or out? How long does this business last for? What's its duration? What is the effect of withdrawing from the company? Are there liabilities to remain a shareholder? Can you end those liabilities when you terminate your ownership? Can you do this on your own, or do you need consent of the partnership to exit? And for that matter, does the business have a lifespan built into it? is the business itself going to terminate after a period of time? If that's the case, what's the mechanism for returning whatever cash is left in the business at the end of its existence? Liquidity relates to the ability to transfer one's interest in a business, so the ability to sell one's shares. And this relates to the investor's financial responsibility to each other. And liquidity of shares involves not only the ability to transfer the financial right in those shares, but potentially also the voting rights in those shares, which can be valuable. Especially in a stock company, having a large voting block can give you a lot of power over a big public company. We can limit liquidity by having transfer restrictions, which can cause the company to keep things within a particular group of people. Whether we want to employ that or not is a question that is based on what the business's needs are. And finally, what do mergers look like? How does the firm end by combining with other firms? Is it difficult for the company to merge? Is it designed to be mergeable? Corporations are very easy to merge, and we do see a lot of M&A activity with corporations. Partnerships are harder to merge, and we do see less activity with the merger of partnerships. What type of approval process is necessary in a merger? Because, some of the shareholders could be harmed, so do they have some rights to protect themselves? What's their approval process for that to happen, and what are the statutory protections around those? So those are the 7 issues in business planning that we're going to focus on. How is the business formed? Who is liable for its operations? Who manages the business on a day-to-day basis? Who gets the return on investment and pays for any additional capital contributions or losses? How long does the business last, and how do investors get out during its lifetime? How do they sell their shares while the business is an ongoing concern? And can the business buy others and absorb other companies into itself or sell itself to another business easily, and with what protections? The answer to those questions will drive our decision as to which entity choice we'll make. Up next, we're going to go through the entity choices, and our first entity selection is general partnerships. So tune in to our next video for information on how general partnerships function, and think about whether or not they are a good choice for the entity in question for your client.